Hello, everyone. Good afternoon. This snowy, sunny day here in Syracuse, New York. Um, Wanted to start off today's presentation with just a couple quick updates on um, the New York State budget. I don't have any slides, but just really quickly, you might recall if you've been a long time attendee of this webinar that last year, I think I did an entire webinar episode about all of the employment and labor related items in Governor Hochul's budget proposal. So I was looking forward to seeing what was there this year so that I could share that with you. Not much at all from a labor perspective, interestingly. Definitely seems like it's not a major focus of her platform this year. And so I don't have a full presentation for you, but I just wanted to highlight a couple things that we're going to be keeping an eye on for you. Really just one thing to be honest, and that is that she's seeking to add pretty significant amount of funding to the New York State Division of Human Rights. That's the agency that processes complaints under the New York State Human Rights Law, does an investigation, and if probable cause is found, conducts a hearing. In our experience here at the firm, we are seeing incredible delays in the hearing processes from the division. Many years, in fact, at this point. So clearly there's, some capacity issues there. And recognizing that the governor's proposing what she's calling a historic increase in funding for that agency to the tune of an additional $11 million, which equates to 108 new full-time employees. So that would be a pretty significant change to that enforcement agency that we think is important, and we will keep an eye on to update you as we follow along the budget process. So just, you've heard of this, perhaps Gabe has mentioned this last week, but what happens is the governor presents her proposal, the legislature then puts forth other proposals, and then they work together and figure out where we land in April. So we will be following that for you. There's a couple other really kind of minor labor things that I won't get into, except one of the things that caught my attention was digitizing youth working papers. I have teenagers who always seem to be losing their working papers. So I found that from a parent perspective interesting, and it perhaps would be easier for employers as well to collect that information digitally instead of a small card, from a teenager. That's about all I have in terms of the New York State budget. There's obviously so much going on at the federal level with the new administration. Don't have any formal presentations on that today, but I just wanted to just let you know, as our attendees that keep tuning in, we're tracking what's going on. There's a lot happening very quickly. We have task force right now examining the executive orders, interpreting them, trying to figure out what the best response will be from our clients. Too early right now, but expect much more content about the federal executive orders and new federal legislation and actions in the coming weeks and months. Okay, so that was my very long-winded introduction. And I'm going to now tell you about today's agenda. We do have a Rochester-only lineup. I just realized that when reviewing the PowerPoint a few minutes ago, just as coincidence, but we do have 3 attorneys all out of our Rochester, New York office. Stephanie Fedorka in our labor department, starting with a new Department of Labor opinion letter about the substitution of paid leave under FMLA, a complicated, confusing area of the law that we want to stay on top of, comes up a lot in workplaces. And then in recognition of today, January 28th, 2025 being World Privacy Day, we have a very robust cybersecurity data privacy practice group at Bond. And so Ariana DeWitz is here from that practice group with a special guest, Jessica Copeland, to talk about that. Then we'll move to Travis Tallarico with an interesting take on some new technology issues impacting the workplace. Wearable technology, what is that and how it might impact employers and clients? All right, that's what we have. So let's get started. I'm going to turn it over now to Stephanie to talk about FMLA. Thanks, Stephanie, for being here.
Thanks so much, Kristen. Always glad to be on the webinar. Kathy, you can advance to the next slide, please. Just a very quick update, because I love when I'm able to clarify something that we thought was probably the Department of Labor's take on something, but I love when they come out and give us guidance that says, yes, you're right, that's our take on it too. So on January 14th of this year, the U.S. Department of Labor issued an opinion letter regarding some clarification on the substitution of paid leave when an employee takes state paid family leave concurrently with FMLA. I think this was prompted in part because lots of state laws now are enacting their own paid family leave insurance laws. We've had New York State paid family leave on the books for several years now. but lots of other states are following suit. So advance to the next slide, please, Kathy. The general rule under the FMLA is that it does allow employers to require employees to use paid time off, like vacation, personal, or sick time, when they're on an unpaid leave of absence. So that's the general rule. FMLA says, yes, employers, you can require employees to use PTO that they have accrued and available when they're taking unpaid leave of FMLA. There's an exception, though, in the law as well. When an employee is receiving payments under a disability benefit plan, sort of like a short-term disability insurance plan or workers' compensation program, then the employer cannot require employees to substitute or use PTO. They can permit that, but because it is not an unpaid FMLA leave at that point in time, because they are receiving cash benefits through the short-term disability insurance plan or workers' compensation, and where that's running concurrently with FMLA, so that's where the employee is unable to work due to the employee's own serious health condition, then the DOL says you have to designate that leave as and run it concurrently with FMLA, but you cannot require employees to substitute PTO. Next slide, please. So that raised some questions because that rule is very specific as to references to workers' comp and a short-term disability type of benefit plan. So the question became, well, what about these state paid and local paid family and medical leave programs that are similar, right? Like New York State PFL. So our position has been that it's similar to short-term disability. And because the employee is not otherwise on an unpaid leave of absence or FMLA leave, that employers cannot require the use of PTO when they're receiving, say, New York State paid family leave. Important to note that New York State paid family leave does have an explicit rule that prohibits employers from requiring the use of PTO. You can allow it under PFL, but you cannot require it under New York State PFL. But what this opinion letter did is it clarified that our position further, right? And so we're certain now that the DOL's position on this is that where an employee is using state or local paid family and medical leave, like New York State PFL, and their leave of absence also qualifies under the FMLA, an employer must designate that leave as FMLA and count that leave towards the FMLA entitlement, and that exception to the rule applies. So an employer or an employee cannot unilaterally require substitution of PTO where they're receiving compensation from that paid family leave benefit program. If the leave is not fully paid, so in New York State, for example, it's 67% of their average weekly wage up to that cap, an employer can allow, and an employee and an employer may agree to allow the use of PTO to supplement those payments. But the big takeaway is that you as an employer cannot require them to use their PTO concurrently when they're receiving PFL benefits and taking that time under the FMLA as well. So take an opportunity to check your FMLA policies and your state or local paid family and medical leave policies to make sure that you have language in there that clarifies that exception, right? You will not require the use of PTO when those leaves are running concurrently under FMLA in that state paid family and leave medical program. And that is my quick update.
Okay, great, Stephanie. FMLA, PFL, PTO, it's a bit of alphabet soup. That's what we do here as lawyers is put letters together. So thanks so much. All right, moving on. As I mentioned, we were going to hear from Ariana DeWitz in our Rochester office. She's going to talk about recent updates to New York's data breach reporting statute. But there's a reason we're talking about this today. And I also wanted to introduce Jessica Copeland, who's the chair of our data privacy and cybersecurity practice group, who wants to also, speak to our audience here. So I'm glad to have you both here to hear about privacy. Thank you for being here.
Yes, and I am zooming in from Buffalo. I've ruined your all Rochester cast today.
No.
Sorry about that. Hello, everyone. We don't have cake and balloons to celebrate World Data Privacy Day, but we do have a very significant update to New York's law that is intended to protect the private information of New York residents. So I'm just here to kick that off and to remind everyone that there's significant content on data privacy topics in our countdown for the last couple of days to today, World Data Privacy Day. So if you haven't had a chance to take a look at that, please visit our website or LinkedIn page. And without further ado, Ariana DeWitz is here to distill all of that important information from New York's data breach reporting statute. Ariana?
Thank you. Next slide, please. So I'm here to talk about the New York Shield Act. The Stop Hacks and Improve Electronic Data Security Act, aka the Shield Act, was signed into law by Governor Cuomo on July 2019 and went into effect in March 2020. This law amended the 2005 Information Security Breach and Notification Act by expanding the types of private information for which companies must provide breach notifications to consumers, and requires organizations to develop and maintain reasonable safeguards to protect the security, integrity, and confidentiality of private information. So this new law is a bilateral focus on breach notification and security implementation aimed to protect New York residents. Next slide, please. So how does the SHIELD Act protect New York residents? Organizations must develop and maintain reasonable safeguards such as detecting, preventing, and responding to attack or system failures, regularly testing and monitoring systems and procedures, regularly assessing risks of information storage and disposal, properly disposing of private information without reasonable time after it is no longer needed. So it's important for these organizations to really reassess how their information is being used and if they're storing data that no longer needs to be needed, because if in the event of a breach, they may have data that they should have disposed of a while ago. And the New York Attorney General really enforces this. Just last year, they imposed about $70 million in damages to organizations for failure to employ reasonable safeguard data protection. Next slide, please. So this new law that was signed by Governor Hochul in December 2024 signed 2 articles of legislation changing the data breach notification requirements of the SHIELD Act. The first one went into effect immediately, and it changes the time requirements for companies to provide notice in the event of a breach. And the second one goes into effect in March 2025, and it expands the definition of private information requiring notice. And I will get into depth with these. Next slide, please. So the first one that went into effect immediately, it provides individual and businesses with a 30-day breach requirement or notice requirement. So they have 30 days to require notice or to provide notice to companies in the event of a breach. And previously, the statute said that they had to provide notice as soon as possible, but now organizations must provide notice within 30 days. And there is no exception. So in the past, they were granted additional time to determine the scope of the breach and to restore the breach system. But now the only exception is in the event that law enforcement requires it. Next slide, please. The next update, can you go back one more slide, please, just for a quick second? So this new timing requirement, the 30 days, this is similar to states such as Colorado and Washington. Next slide, please. So the second law that goes into effect in March 2025, it expands the definition of private information, which is important because to know what an authorized data breach is, it's the unauthorized access to private information. So organizations should know what entails private information. And this may vary from state to state, but since we're talking about New York, we're going to discuss the New York one. So private information includes personal information such as social security numbers, driver's license or ID numbers, account numbers that allows you to access the individual's financial account, biometric information, and then usernames in combination with security information that allows you to access online accounts. And this will be updated with the 2 new definitions that I'm going to discuss on the next slide. So the 2 new definitions that will be included are medical information and health insurance information. Medical information is any information regarding an individual's medical history, mental or physical condition, or medical treatment of diagnosis by a healthcare professional. Health insurance information is an individual's health insurance policy number or subscriber identification number, any unique identifier used by a health insurer to identify the individual, or any information in an individual's application and claims history, including their appeals history. And this is important because previously, organizations that were not required under HIPAA to report a data breach, so they were not a covered entity or a business associate, they did not have to report a breach. But now, if they previously were not required, these two added definitions adds that requirement. And correspondingly, the bill amends the New York Penal Code to add medical information and health insurance information into criminal identity theft statutes. Next slide, please. So the key privacy protections to help ensure data security is to have a comprehensive security program and make sure you're designating an employee to just oversee and continue to follow updates. You should train and manage your employees in the security program practices and procedures. You should assess risks in network and software design. You should protect against unauthorized access to or the use of private information, and you should dispose of private information within a reasonable time after it is no longer needed. Next slide, please. Oh, I'm missing a slide, but I think organizations should just be sure that they're following the updates. If you have a comprehensive one, if you don't have one, you should get one. But if you do have one, be sure to update it to comply with these updates. Thank
And
you.
since we have one more minute, I'll just chime in. So a couple of other factors to think about in terms of compliance with the safeguards illuminated in the SHIELD Act are to make sure that you have security measures like multi-factor authentication, threat monitoring on your systems. Those are technical safeguards that aren't necessarily spelled out by the SHIELD Act, but certainly in the enforcement actions under the SHIELD Act or non-compliance of the safeguards, we're seeing that the Attorney General is then requiring organizations that suffered a data breach to implement those security measures going forward. So that's just something to keep in mind. Thank you for letting me jump in here, Kristen and Ariana. And I think that rounds out the New York update on data privacy law.
Great. Thanks to Ariana and thanks, Jessica. It's actually a treat to have you both here. So I really appreciate it. And like Jessica said, there's a ton of content on our website. The group has been very, very busy putting out data alerts, information updates about a wide variety of data related topics. I've enjoyed reading them. So definitely encourage you to go to bsk.com and check that out.
Thank you, Kristen.
Yeah, no problem. So before I move on to our final presenter, Travis, I was just keeping an eye on the Q&A. There's a lot of questions about PFL and FMLA and substitution. Steph, if you're there, I just wanted to just throw out one question that a lot of people have been asking, which is, I know you were talking about paid family leave, but you also mentioned short-term disability. And under New York State short-term disability, there's a 7-day waiting period. And so the question was whether you can require substitution for that 7-day waiting period. I think you've already answered it online, but given how many people asked, I wanted you to share that with everyone.
Yeah, no, I think the answer is yes. I have looked into this before and there's no clear answer, interestingly enough. But if it's purely just FMLA and it's unpaid because they're not receiving benefits during that time, then I think that FMLA rule as to when you could require it would apply. So I think the answer would be yes. I would caution though on paid sick time. I would not require the use of paid sick time under New York State law or any other similar state paid sick leave law, because those are more protected. And I generally take the position that you cannot or should not require an employee to use their statutory paid sick time. But work with counsel in terms of what you're comfortable with. But I think, and with insurance, I always recommend checking in with your insurance carrier to make sure that there isn't anything funky, because I have actually seen, someone asked in the chat too, can you require employees to use the paid sick time if it's not FMLA while receiving short-term disability benefits? And I have received a mixed bag of answers from various insurance companies, and there's no clear answer in the law on one way or another. So work with your legal counsel to figure out what you're comfortable with and give you some recommendations on how to handle that if you have questions.
Great. Thank you. And Steph is, I can tell, diligently looking at that Q&A, trying to get back to people. You know, not surprising. Anytime we have a topic about FMLA or PFL, lots of questions. It's just, you know, rife with confusion because the regs are pretty complicated. All right, let's move on to wearable technology. I'm probably starting with what the heck is a wearable technology? Perhaps it is the watch I have on my wrist, I'm guessing, and some other things as well. And you know, it's always, we forget sometimes that some of these things that are entering our everyday life have some legal implications as well, right, Travis?
That's absolutely correct.
All right, well, go right ahead and tell us about it. Thanks for being here.
All right, thanks, Kristen. Hi, everyone. Happy to be here as always. So today going to be talking about some of the legal implications of wearable technology in the workplace, and I will have a definition of exactly what wearable technology is at this moment. And I have to say, even you know, until coming across a recent EEOC fact sheet that came out about this concept, is frankly one that I probably wouldn't have thought of. But after kind of going through this and learning a bit more about it, is definitely something I think will be very important to consider now, and particularly as we move into future and our technology continues to advance. So Kathy, if we could move to the first slide, that would be great. So the definition we have of wearable technology is a digital device which is embedded with sensors and worn on the body that can keep track of bodily movement, collect biometric information, or track location. So as Kristen mentioned, very well could be a smartwatch. It could be some of the smart rings I know that used to track health data, things like that. Now, I don't use any of those myself, so I'm not super familiar with any of this technology, honestly. But there's, in addition to kind of the basic stuff we might use in our day-to-day life, there's also additional technology coming out, such as smart glasses or smart helmets that could measure electrical activity of the brain, exoskeletons, which can provide additional physical support or reduce fatigue, and GPS tracking devices. So these are all you know, potential technologies that might be worn in the workplace, and if they are mandated to be worn by an employer, could have some implications, as we'll be discussing over the next few slides here. So first, we need to consider is if an employer is going to be mandating that employees are wearing this type of wearable technology for their day-to-day job functions, need to be considering exactly what we're doing in terms of collecting this information and how it might be implicating the ADA. So this could be potentially considered a disability related inquiry if they are this technology is directing employees to provide health information such as information about prescription drug use or disability in conjunction with using some of their wearable technology. So as a refresher for everyone, the ADA does impose some strict disability related inquiries or medical examinations for all employees, not just those with disabilities, limiting it to situations when it is job related and consistent with the business necessity for in positions affecting public safety, or if the inquiries or medical examinations are part of a employee health program emphasis on voluntary health program. Next slide, please. So just as an example, so we could kind of maybe have a bit more common sense of what this might be looking like. So say, for example, Fred's employer tells him that he must wear a company issued tracking watch. So in addition to his GPS to track his location, the watch also collects Fred's vital signs and information about his gait, as well as other general information. Now, this mandatory use of the watch likely would not satisfy the ADA's requirements for employee health programs that are voluntary, and this also could possibly constitute a medical examination under the ADA. Now, as an additional point of consideration, if an employer does collect medical or disability related data from a wearable device, the ADA requires employers to maintain that data in separate medical files and treat it as confidential medical information with some limited exceptions. And next slide, please. So in addition to collecting this information, need to consider how we are using it if we are doing so. So when an employer uses information collected by wearable technology, even if it was permitted under the ADA, the employer must comply with any and all non-discriminatory requirements of all the equal opportunity laws. And relatedly, if an employer uses wearable generated information to make an employment decision that has an adverse impact on employees because of protected basis, this could also implicate a violation of some equal employment opportunity laws, as we'll be explaining on the next couple slides. So here, just a couple examples of how this could come into play. So say we have a pregnant employee might be able to pick up or create an inference based on heart rate, fatigue level, or temperature information that employee might be pregnant, and then taking adverse action because of that inference. Relying on data from wearable technology that produces less accurate results for individuals with darker skin color, which could implicate discrimination based upon race or color if an adverse employment action were taken based upon any information gleaned in that instance, or taking adverse employment action based upon an elevated heart rate when the elevated heart rate results from a heart condition implicating potential disability. Or relatedly, just requiring only certain classes of employees to wear wearable technology also could implicate an EEO violation. Can't really see a practical scenario where this would happen, but say just for example, if all female employees were required to wear wearable technology, but male employees weren't, or insert your other protected class there. Next slide, please. Well, sorry, I do not think that we might be out of order on our slides there. I don't know if there we go. Okay. Thanks, Kathy. And so kind of the last main point here is if a company does mandate that wearable technology is worn, this might implicate the need to provide a reasonable accommodation as well, both under Title VII, particularly if it might implicate a religious belief, the ADA, or the Pregnant Workers Fairness Act. Just as a couple examples here, even if an employer were to comply with the ADA's limitation on collecting medical information, the employer might need to excuse an employee from wearing a device if doing so is against the employee's religion and provide some sort of alternative. And likewise, kind of similar concept for any employees if this would have any issues implicating their pregnancy or their disability. So I think practically this is definitely still a pretty novel concept. I can't say I have encountered this in practice yet of where an employer is mandating the use of any of this type of technology, but due to some of the the positives it could bring and some of the common sense elements, right? Again, I mean, just what I think is a GPS watch to be able to track employees, their productivity, all of that good stuff. I do think this is something that we will be seeing more of in the future, and particularly so given the fact the EEOC decided to put out a fact sheet on this means that it's something that that agency is considering as well.
Thanks, Travis. I think you're right. I think we're going to see more of this, and the EEOC is just getting ahead of it in a way, I think. So thanks for your time. All the presenters, you're great. I appreciate you being here. I think we have another slide here that will have their contact information in case you wanted to follow up with any of them individually. You can always follow up with me as well. Appreciate everyone coming, and we will be back here in a week. Gabe Wilberfield will be back hosting, and then I'll see you the week after that. Take care.